Hello, everybody. Welcome to Free Kiwis. Today, I'm delighted to have Abhishek Saha, who's a mathematician, a mathematics professor at Queen Mary University of London. And you may recognize the name because, if you're in New Zealand, because I actually had him on not the Free Kiwis podcast before, but the New Zealand Initiative podcast to talk about academic freedom legislation in the UK. So, welcome again, Abhishek.
Thank you for having me.
And we're going to talk on a similar theme today because the legislation that the last conservative government, created about free speech or academic freedom has gone through now, and now there's a very important court case in the Royal Courts of Justice. I went in the other day. I sat next to you on this very antiquated kind of pew, incredibly uncomfortable, quite a small courtroom, and I basically had no idea what was going on. So can you just tell us what is this case about and why is it important?
Yeah, so this case has its roots in the departure of Kathleen Stock from Sussex in 2021, which made a lot of news, I think, worldwide, because Kathleen Stock had faced protests over her gender critical views, and basically her working life was made intolerable and she was hounded out of her job, essentially. She resigned. So the Office for Students, the OFS, which regulates universities in England, decided to open an investigation into Sussex around the same time of Stock's departure in October 2021. But funnily, the investigation and the eventual fine doesn't actually have much to do with Kathleen Stock at all. And the reason for that is the OFS didn't at that time, and in fact still doesn't, have the power to investigate cases where individual academics have suffered a breach of free speech or academic freedom. Instead, what it has the power to do is to see whether universities' documents and governance arrangements comply with what are called registration conditions. So these are powers that the regulator, the OFS, had and still has. This has nothing to do with the new Higher Education Freedom of Speech Act. These powers have been there for a while. So this case basically doesn't have anything to do with the new legislation. It is what the investigation focused on starting in 2021 were on two of the registration conditions that universities have to follow. They are called conditions E1 and E2. So condition E1 requires universities' governing documents to uphold certain principles, which include free speech and academic freedom. And condition E2 requires universities to have effective governance arrangements in place to deliver their principles. So, after an investigation that ran on for 3.5 years, the OFS fined Sussex University a big sum of money, £585,000, for breaches of these two principles. And what it found was that a particular policy statement they had called the trans and non-binary equality policy statement required, among other things, that all materials in courses and modules will positively represent trans people and trans lives, and it had other similar clauses. They found that it created a chilling effect on academic speech in the classroom and beyond, and thus this document failed to uphold free speech and academic freedom, breaching the condition E1. And it also found that governance arrangements didn't support it. So that was the breach.
Okay, so that's very interesting. So I got that completely wrong. So it's nothing to do with the new legislation. This case was brought sort of 3 years ago, and it took a while to come in. So am I understanding it right that the Office for Students sort of independently did this back in when? 2021, 2022? And so
Yes,
that's before they even
uh,
had an academic freedom czar, right? Arif Ahmed
that's
in post yet.
That's absolutely right. The Office for Students started it. This was long before Arif Ahmed became the freedom of speech czar, as it's called, the director of free speech and academic freedom. It was before the legislation was even in, basically the legislation had just barely been introduced at that point in Parliament. So it was long before all that. The investigation took a long time. Sussex was presented with provisional findings, which they really fought back and sent back to the OFS a 1,500-page document about why they should not be fined. It went back and forth. So finally, in 2025, last year, the OFS reached the final decision that, all right, you have breached our registration conditions, you are getting fined £500,000. And Sussex didn't pay the fine. Instead, they are challenging it in court. And so last week, so just recently, so you were in court, that's when the hearing for Sussex's legal challenge to the fine took place over 3 days.
Okay, I mean, this is just a sort of an opinion, but do you actually think that it genuinely had nothing to do with Kathleen Stock, or do you think the fact that Kathleen Stock was a high-profile case kind of prompted the Office for Students to look into Sussex and what they were doing and their own statutes?
Absolutely. I think the what happened to Kathleen Stock did prompt the OFS to look into Sussex, and because the OFS could not directly um, punish the university for example, failing to stop harassment of Stock or for failing to uphold a free speech, it instead has gone about this very narrow power that it does have, which is to look at registration conditions. So it is kind of the only tool they had at that time to do something about it. And in fact, Stock does play a minor role in the eventual case because the OFS is relying on two witness statements provided by Kathleen Stock, which says that her of that she suffered a chilling effect on what she could or could not say in the classroom because of this particular policy statement that was eventually found in breach. So it's not about her being hounded out, but it's about she does give evidence that she got chilled in before she left Sussex due to these statements. And that's partly some of the things that OFS has relied on to issue this fine. But Sussex, in challenging the fine, is using 6 grounds, and many of them have sub-grounds. So if I counted it, there are in fact total 12 grounds if you count the
Okay,
subparts, and they're very far-reaching grounds. It could completely change the OFS's powers if these are upheld.
okay. So from what you've told me, Sussex University, University of Sussex, has an obligation to protect free speech and to have regulations in place that protect free speech. At the same time, it has a regulation on the books, or had, probably still has, which, part of that says what, that you have to create a positive image for trans people. So if that's right, if it's anything like that, it seems to me that it's just obvious that they're not defending free speech. So what's their defense?
So Sussex is challenging on several grounds the fine, and the first ground is that it's that this policy statement was not a governing document. So that's a kind of technical term because the Office for Students is only allowed to find breaches if a governing document fails to uphold free speech and academic freedom. So Sussex is saying that this is not even a governing document. And this then goes back to what is a governing document. It turns out that the act that gives the OFS these powers did not actually define the term. So Sussex is relying on an older concept of governing documents coming from charity law and so on that is very restrictive. It only is about statutes and very foundational documents. OFS has, for the last 7 years, used a very broad definition that definitely captures this statement. So they're fighting out in court about what this even means. And so if Sussex wins,
Yeah,
it would
I mean,
essentially kill the entire power.
you'd think that if you think about the intention of E1 and E2, especially E2, that you have to have something on the books that defends free speech. They probably weren't thinking it has to be a governing document or a non-government governing document. They were thinking about something that actually has teeth and that does something at the university, right? So it doesn't really
That's
seem.
exactly, yeah. So that's part of OFS's difference. It says that if Sussex's position is upheld by the court, it would be absurd because it would run contrary to what what Parliament had in mind when it gave the OFS all these powers, when it in fact created the OFS essentially to regulate universities. Ground two, in fact, is even more perhaps far reaching. It's saying that the OFS has no power to even interpret governance arrangements internally because only the king has that power because a Royal Chartered University. So this is really, again, a very technical and far reaching ground. It says the OFS's power that it has assumed for so many years don't actually exist for
Wait, wait,
chartered
wait. Okay,
universities.
so this is strange to me because I mean I grew up in Commonwealth countries, and well, Commonwealth countries that had the monarchy, because I know some
Mhm.
don't. But in New Zealand and Canada, often in legal parlance, I'm not a lawyer, but I understand that you hear this in the news a lot. They talk about the crown, and
Mhm.
it's technically when you have cases, it's the crown versus somebody, but it's not literally the king or the queen, right? So surely in this case
Right.
as well, their power is vested in the office of students by the state, which is symbolized by the king. But it's not like Charles is, doing everything, right? And taking all these cases himself.
You think that, but Sussex says that Parliament never explicitly transferred these powers from the Crown to the OFS. It did transfer certain powers, but not the power to interpret universities' internal laws, internal policies. So it's saying that power is still with the crown, and the OFS cannot actually take that over because there's no law that allowed it to. So it's another very far-reaching ground, and we don't know what the judge will think of grounds one and ground two, but if she rules, if she finds for Sussex, it would clearly change the office's powers in ways that go far beyond this particular case.
I mean, that would suggest if the judge upheld that, it would suggest that Parliament did a very poor job, or whoever passed the original legislation we're talking about did a very poor job in making clear that the legislation had royal assent, right?
Yeah, so the legislation we're talking about is a 2017 legislation, the Higher Education and Research Act called HERA, which created the OFS in the first place. So, yes, it does not define what a governing document is. And though it is implicit in my view that the OFS has all these powers to interpret internal laws, otherwise, some of the provisions don't even make sense.
Yeah.
It turns out the judge said, all right, I read the white paper and the green paper leading up to the act, and it never mentions anything about transferring this visitorial jurisdiction from the crown to the office. So why am I supposed to assume it did that? So yes, you're right. There certain things were left unclear, and it's a matter of statutory interpretation now.
So does this go back to the really sort of old-fashioned thing at British universities that there's an official visitor? Like I remember
Yes,
colleges at Oxford
yes,
had like, the Bishop of Winchester or something. In the very old days, that person would be a kind of inspector.
yes. So ground two of Sussex says that the visitor has the power to interpret internal laws, and OFS does not have the power. In fact, they say visitor has exclusive power. So the OFS cannot interfere with the visitorial jurisdiction. It has not been abrogated. That is
Okay.
Sussex's ground two.
So I guess the worst case scenario here is that the universities or like the government, I mean, maybe this government wouldn't be cooperative, but the government would have to go to Parliament and say, look, we passed this legislation a few years ago. We didn't make clear that the OFS actually has jurisdiction or permission to intervene in this way. We've got to have a supplementary bit of legislation that says, okay, the OFS is allowed to do what we thought it would be allowed to do.
Yes, that would be one way to get around it if the judge finds for the OFS. Or, yeah, I don't expect that to happen from this government, to be honest, but absolutely a legislative route would be the preferred things to way to make it clear. I should mention that whatever happens with this case, it's almost guaranteed to be appealed because I don't think either party is going to accept the High Court's judgment because there's too much at stake. So it is going to go to the Court of Appeal. I think it's almost certain. And then the Court of Appeal could always reverse the findings and so on.
So what court is this actually in at the moment? Sorry?
It's currently in the High Court.
The High Court. Okay,
It's
so the
a
High Court is
yeah.
the Court of Appeal, and then there's the Supreme Court.
Yeah, potentially. So High Court, so it's a particular branch of the High Court called the Administrative Court, where judicial reviews take place against universities and so on. So this can be appealed at the Court of Appeal, and yeah, potentially the Supreme Court, which that would be a bit more rare. But yeah, these are the next possible levels of appeal. Yes.
Okay, so what's Sussex University's ground three?
So Sussex University's ground three is that the OFS got the law wrong, namely that the OFS misinterpreted what it even means to uphold freedom of speech and academic freedom. And that's really interesting. So assume that the OFS has got it right on governing documents, got it right on ground one and ground two. Sussex is saying even then, this policy document doesn't actually breach academic freedom because academic freedom is as defined to be jeopardy of losing job or privilege. And Sussex is saying that Kathleen Stock or any other academic, if they decided to violate this policy, they wouldn't actually have been fired or dismissed or caused some disciplinary action that would lose them privileges because they're saying there is some other very high level statute, which called Statute 7, which essentially says that staff's academic freedom are protected. So if everything went in the perfect manner in a disciplinary proceedings, then that academic who decided not to represent trans lives positively and so on would still be safe. The OFS's reply to that is upholding academic freedom is much more than just having one fine high level policies, high level statute that
Yeah.
protects it. You have to actually do a better job, and you did not do it. You did not uphold academic
Well,
freedom.
it would suggest that academics aren't intimidated by, and there's no chilling effect from anything other than a direct threat to lose your livelihood and your job and your career, right? So
Yeah.
it would
So
suggest,
that the chilling effect is absolutely the main point here because OFS did find that this created a chilling effect. And in fact, the judge also seemed to agree it causes chilling effect. Sussex says even a chilling effect is not enough to breach academic freedom because we had enough protections in place. So even though someone felt a chilling effect, in reality, we would not actually have done anything to that person.
Yeah, I
So
was
it's a
actually in court for this bit. I remember this quite well. The judge was quite dismissive, I think rightly, of the guy for Sussex University, the lawyer for Sussex University's argument here, because he was basically saying, well, look at what the statute actually says for the university. It says that, we might investigate you, but the investigation, might be very short. And,
yeah.
there's also this academic freedom statute, so you'll be fine. And the judge is quite rightly saying, well, no, if you're an academic and you even get something on your record or you get investigated, that can be extremely onerous and stressful. And I agree with this, having been in that situation myself.
Yeah, absolutely. So Sussex is saying being onerous, being stressful, all of this is not really the concern for academic freedom. And they're also saying something else on ground three. Ground three actually has three subparts. They're all kind of different. So they're also saying that that OFS failed to take a proper proportionate approach. It took an absolutist approach to free speech. It was like all or nothing. You have to protect all speech that is lawful, while in it has to kind of take a more proportionate approach. Was this trans policy, even if it did cause some kind of chilling effect, was it justified? And if it was not, the OFS had to analyze and say why not. And it says that it did not kind of do all of this. So that's another ground. And then they also are saying it did not consider the different governing arguments together. So there are a bunch of grounds clumped under ground three, which all essentially boil down to saying the OFS did not properly apply the meaning of free speech and academic freedom within the law. So,
All right,
and
let's
yeah,
move on. We've got three more grounds, right?
yeah, we have three more grounds. So ground four is actually quite close to what we just talked about. The ground four is essentially saying that chilling effect and the threat of disciplinary action is not the correct thing to look at because the OFS had to look at how this trans policy and what would actually mean on the ground. Sussex thinks that the trans policy would not actually cause disciplinary proceedings. It would not actually cause people to be fired. So it should really not be a breach. The OFS is saying that even if such a complaint against a staff member would ultimately fail, it did threaten disciplinary action. It did cause a real world chilling effect. One has to look at how these things work in the real world. One can't just work in the abstract theoretical law. So this kind of real world chilling effect is important, and that's their rebuttal to ground four. Um, yeah, I can get to ground five, which actually has 3 points. Um, and basically, ground five is different. Ground five is saying that you are unfair to us. Sussex is saying we took into account the moment you contacted us, we kind of remedied things. We withdrew this policy. We started remedying stuff. We created a safeguarding statement that said, in addition, that staff will not be punished um, for exercising academic freedom. And it's saying that you are basically being unfair to us. We did all of these kind of things, and therefore your finding was essentially irrational. It was an irrational and unfair. It was not as significant as severe breach of academic freedom and free speech. So again, it kind of is a bit more procedural. It's not as far reaching as the other grounds, but it's kind of saying that Sussex was singled out for a fine.
So is that true that they withdrew the statute? So it's no longer on the
No,
books.
so basically they um, modified this particular trans policy multiple times. They modified it, I think, in 2022 or 2023, and again in 2024. So the OFS found that even the first modification still failed to properly uphold free speech and academic freedom. And the second modification, which was only like 2024, it did not, the OFS did not come to a decision on whether that was okay or not. But essentially, the OFS is finding it for a historic breach that was in place from 2018 to 2023. And Sussex is saying, all right, even if we were to accept that we failed to uphold these conditions, we did, at least in very recently, take steps to remedy it, and that should have been considered. And I guess OFS is saying, yes, we considered all of that, but it was still a very significant breach that went on for a very
Yeah.
long time. And at some point, we had to stop the
And I
investigation and
suppose
come to a
without a
decision.
fine, there's no disincentive, right? So other universities could just have things like this on their books. They put out statutes and then just sort of hope that the OFS won't notice it and that they'll maybe get the
Yes.
legislation slightly wrong so they don't give the king or they don't get the power from the king or whatever. So, I mean, without a fine,
Mhm.
there's no reason why you wouldn't do that, right?
Yes, because a lot of these changes did happen more recently. And by 2023, I think Sussex was already kind of getting the idea that it might get a fine eventually from the OFS. So there was already an incentive for it to make these changes. Um, so
Hmm.
it's unclear to me how far this ground five would go, but I think this would not change anything about the OFS's powers. If this is the ground on which they win, it is more like kind of saying that we should have been treated a little bit better, perhaps on this particular case. Um, Ground six, the last one, also is kind of a bit more procedural. So it's basically saying that a few things like the OFS did not properly disclose Kathleen Stock's second witness statement that she kind of said about her chilling effect. It's kind of procedural about how this investigation went. There's one more thing there in ground six that said that OFS is biased and that essentially it had made up its mind from the beginning to find Sussex. And the way the Sussex is claiming this is saying Sussex is directly targeting Arif Ahmed, who is the director of Free Speech and Academic Freedom, saying that he had written in favor of Kathleen Stock long before he took up his current position because to support free speech and academic freedom. So Ahmed should not have been in charge of the investigation. But in fact, as the OFS makes clear, Arif Ahmed was not actually in charge of the investigation until the very end. Arif Ahmed joined the investigation in towards the end of 2024. So it was almost 3 years after the investigation started that Arif Ahmed even had any role to play. So I think again, this was a ground that the judge did not
Even if he did,
really.
I'm sort of trying to think about this. I don't know what the law says on this, but like, say I think there's a problem with like drug dealing in London, and I write articles about it, and then I become a police officer, and I rise to the top, and then you know, prosecute. I don't know how this works. I prosecute someone for drug dealing or like a load of people, and the judge says, you were biased against drug dealing because you wrote articles about it. I mean, or even if it's a particular case, right? Even if I think like there's this gang in Clapham that's dealing drugs, and then later I prosecute those people having published articles about it before. That kind of makes sense, right? Like that's sort of what you would expect.
Absolutely. And that is a point that the OFS's barrister made in court that Arif Ahmed was appointed to this role because he has always supported free speech and academic freedom. So it's not surprising at all that he wrote articles supporting Kathleen Stock's free speech and academic freedom. It had nothing to do with him supporting her views. It had nothing to do with whether he is supporting gender critical views or
Mm.
trans rights views. He just supported her free speech. And in fact, he was not even part of the investigation until very late. And even then, he did not issue the final fine. It was issued by the decision-making committee, which it was not him. So I don't think this ground is actually going to go anywhere. It could have hurt Arif Ahmed if it did, but I don't see this particular ground going anywhere. I think it's more grounds one, two, and maybe ground three that we
Well,
really have to
did you
that
miss
could.
this? Maybe I missed this. It was underground three, but I definitely heard in the court this argument. It sounded like Sussex were going to argue, or they did argue that they're allowed to infringe. They're allowed to limit speech in a way that goes further than the simple sort of background law. To
Yes.
do things such as make for a respectful environment at the university, right? So you're not allowed just to stand up in the middle of the classroom and shout boobies or something. You're not allowed to abuse someone who's making giving a lecture, even though that actually has happened. But it, Sussex are, as I understand it, saying like they're allowed to limit speech in some ways, right? As long as those are reasonable and proportionate.
Yes, this is what I didn't really talk about. This is ground 3D. I kind of brushed it under because ground three had so many
Yeah.
subgrounds. So ground 3D basically is about what does it mean to take reasonably practicable steps to protect freedom of speech within the law. And initially, Sussex and the OFS had different legal interpretations, but when they did come to court, they actually agreed on the legal interpretation of what it means. So the agreed framework is as follows. First, you see if the speech being restricted is lawful.
Mm.
If it is lawful, you are still allowed to restrict the speech, provided that it is not reasonably practicable to allow that speech, and that any such restrictions have to be proportionate. So this is where the two sides do agree in the end.
Okay.
But what Sussex is saying is OFS did not actually apply its own framework in how it conducted the investigation. Now they're saying, all right, we agree with the OFS that there are certain situations in which lawful speech can be restricted, like what you're saying, someone in the classroom kind of raising irrelevant topics. Okay, that is lawful speech, but you can restrict that. But it's saying that Sussex is saying that OFS did not do this thorough analysis of whether Sussex's policy did or was not or was proportionate in this framework. So that is Sussex's challenge to OFS.
But
OFS
I
saying, no, we
also hear
consider
at
all
some
of that.
point there was a bit of a back and forth about the European whatever it is, legislation on human rights and whether that applied in Britain. And the judge seemed quite forthright that the European legislation basically was UK legislation effectively. And that had some bearing, I think, on this idea of
Absolutely. So that is closely related to this particular ground. So initially, so this is a little bit technical, and if this was, so this actually can go really far. So initially, Sussex took the position that they can restrict any speech as long as they do it in one of the grounds that the European Convention of Human Rights, Article 10.2 allows them to. And 10.2 actually allows universities to restrict a lot of speech. OFS had countered that with saying, no, you have to not only satisfy the 10.2 criteria, you have to also make sure that it is not at all reasonably practicable to allow that speech. So that actually, OFS took a much more speech protective view than Article 10.2. So this was the initial clash in the initial grounds. But when they did come to court, it turned out that essentially Sussex had agreed with the OFS and said that, all right, we accept that it does not have to be just 10.2. It has to also be reasonably unpracticable to allow the speech. So they actually agreed there. So there is the Article 10 that's coming up, but there's also additional thing. But underlying all of that is still it has to be there has to be a reasonable test. Is it reasonable to allow this speech? So there both sides do agree, but initially they disagreed on how to exactly make that work in practice. But now they are saying they agree on that. Now the fight is essentially on whether OFS actually followed this agreed framework. The judge, on the other hand, did seem to kind of stick to the initial thing that Sussex had offered, which tied it very closely to Article 10. But essentially, the OFS was telling the judge that no, that is no longer a ground we are fighting on. So we don't need to go there. We have a much more narrow question. So I was really worried about that because the original thing that Sussex was arguing could have potentially destroyed the entire OFS legal framework, including the Higher Education Freedom of Speech Act, which has been interpreted in the same way. But it
so
seems
essentially
that,
what you were
yeah,
worried about was the idea that the European Convention for Human Rights, what was it, 10.2 or 10.3, that would
yeah,
trump the powers of the OFS to
right.
protect intervening
I
universities.
was worried about that. Exactly. I was very worried about that, but it seemed that somehow on the day of the court, or maybe a day or two before, Sussex decided to withdraw that particular legal ground and instead fight 3D on a different kind of narrower procedural ground. So I'm hoping that that particular worry is off the table because both sides seem to have
Yeah.
agreed on the legal interpretation.
Okay, well that's a relief. But I mean, you've been tweeting about this quite a lot, and you actually spent like 3 days in court following all the proceedings. So you're obviously quite worried about this. So what's at stake here? Why do you think this case is so important?
I think it's very important because all the grounds are so far reaching. Ground one, if Sussex wins on ground one, it would essentially greatly limit the OFS's E1 powers, the power to find university in breach of E1 governing documents. If they win on ground two, it would essentially kill its E2 powers for any university founded by Royal Charter, and there are like 50 of them. And then the other grounds, while it would not necessarily have such a big impact beyond this case, it would still quite severely hurt the OFS. If, for example, grounds 5 or 6 were upheld that it has been very unfair, it has singled out Sussex, it could impact its future standing. So I think this case could have repercussions. The way this case is decided could have repercussions that go far beyond Sussex in particular. So that's why I'm worried about what might happen. On the other hand, if the judge does decide for OFS, I think it would reinforce and vindicate the very robust approach that the OFS has taken to protecting free speech and academic freedom. And one last thing I think that is very important to keep in mind is that none of this would have happened if the Higher Education Freedom of Speech Act powers of having a complaints scheme for academics had been in place in 2021,
Mm.
because in that case, there would have been no need to go through this convoluted route. Instead, the OFS could have just investigated, did Sussex breach Kathleen Stock's academic freedom and free speech? And that would have been a much more simple kind of perhaps case that would have played on different grounds. And miraculously,
I see,
even
because
now,
then they would look
this,
at the individual case rather than the sort of broader question of whether Sussex is allowed to have these regulations.
yes,
I mean,
exactly.
if they did the individual case and they found that it had actually, unjustly limited Kathleen Stock's free speech, that would probably have applied to the broader regulation that Sussex had in place, though, right? They would have
It
established
could
precedent.
it could have, but then it would not depend in any way on whether this particular document is a governing document or not. It would not
Yeah,
have depended on any of those things. It would have just depended on whether Kathleen Stock was chilled, whether her academic freedom was breached, whether she was, whether the universities took enough steps to protect her freedom of speech. It would have decided on these kind of grounds. So, though the Higher Education Freedom of Speech Act, which is very important, passed in its main duties came into force last year, the complaint scheme, which allows the OFS to investigate such breaches of free speech and academic freedom, actually still has not been activated. It is still sitting with the government. And I think this case, whichever way it goes, really demonstrates the need for the government to actually activate the complaint scheme. Because clearly, these existing powers that go back 8 years, the E1, E2 powers, are limited. They only apply to these very narrow governing documents, governing
mhm.
arrangements. They're prone to being challenged by judicial review, and they're clearly very high stakes with gigantic fines after years. In contrast, I think the complaint scheme would be wide ranging but low stakes. There would be simple individual cases, not such a huge fine necessarily. The university would be kind of told to, all right, this didn't quite work, you should do it differently. And I think through this kind of steady accumulation of precedents, it would
Yeah,
help universities figure out what they can do, what they can't do. Instead, we have this big case where both sides kind of feel like everything is at stake and they have to fight out. I bet Sussex has spent so much more money than the fine
yeah.
itself kind
And
of
it strikes
fighting
me
this
that
case.
England and the UK are interesting cases because just sort of rationally thinking about this sort of carte blanche, you would think that it's a liberal democratic society, taxpayers are paying for universities, so the government should be able to intervene in institutions that it basically sort of owns. But of course, there's all this history and common law is all about precedent, and these are ancient institutions, so they're founded by charters from the king, or a lot of them are. Um, so it makes things difficult. I mean, I'm just trying to think our experience in New Zealand. I mean, in New Zealand, it's simpler because the universities were basically created from constituent colleges of the former University of New Zealand at a certain point, and then in the Education Act, it actually says this is the definition of a university. It has free speech in it. And now the recent legislation has basically said we're requiring universities to have free speech policies that must have the following features. And that's much easier in New Zealand because you don't get this thing of like, oh, this university was founded by the king in 1503 or whatever, and it has a visitor and et cetera, et cetera.
Mhm.
But I mean, that original way of thinking about it as like carte blanche of, the government should be able to set conditions on universities that it's funding. That still makes sense, right?
Absolutely. I mean, I think a lot of it ultimately boils down to what are the limits of institutional autonomy? At
Yes.
what point can the government intervene? And I think that is one of the reasons why Sussex is fighting so hard, because they feel like they should have more institutional autonomy to decide some of these things. But you're absolutely right. All these universities in England are getting funding from the government, from the OFS. They are regulated entities. They're not just
Yeah.
private, yeah, organizations that can do what they want. And so that is really where some part of the clash is coming from, I feel. And
Yeah.
yeah,
I think in that in universities, I mean, in New Zealand, the response from a lot of academics to the idea of any legislation around free speech or the right of the government to intervene in order to guarantee free speech has been to say, oh, it's our autonomy. They're clamping down on our autonomy. This is really dangerous. The state's intervening in universities. Universities have to be independent. And I'm like, of course, I completely agree with that. So if we were talking about, for example, the government read your papers on number theory and said, Abhishek, you shouldn't be writing about prime numbers. Or, more seriously, there was some Marxist economist and the government said you can't do Marxist economics, you can't quote Karl Marx or something. I mean, that would be ridiculous. But what I think that's a misunderstanding of what we're trying to do and what the governments in New Zealand and the UK are trying to do. I think what they're trying to do is precisely to make it impossible for anybody to stop someone studying Marxist economics, money, number theory, or indeed to have, gender critical views about feminism and to promulgate those. So it's actually not intervening in the bad sense of like making it possible to argue X or Y. It's intervening in the sense of we want to guarantee that people can argue X, Y, or Z.
Yes, and I think this was a point also raised in court when the OFS counsel, she said in relation to Arif Ahmed's past writings and also the way the OFS has been implementing these conditions and the legislation and protecting academic freedom is that it's viewpoint neutral. It doesn't favor one viewpoint or the other. It's not like some of the laws that we have seen in some US states where it says that gender is should not be covered in class, gender identity should not be covered. It's not like that. It has nothing to do with whether you can study some particular subject or say certain things or not. It's just saying all views are equally protected, and universities need to take some steps to protect these expression of views and to ensure that academics can't kind of be chilled or suffer breaches of free speech rights when they express these various lawful views. That's really all that comes down to. I think that's a very reasonable intervention in universities. You might argue that technically it is breaching to some degree institutional autonomy if you define autonomy to be very broad, but I think it's a justified breach of autonomy because I don't think institutional autonomy is something absolute and far-reaching. I think
Yeah, yeah.
governments have a role to play here.
That's the thing,
I
like
mean,
if we're collecting all this tax money and giving it to universities, and imagine like we found out that universities are just spending it all on a gigantic ice sculpture or using it to fund football games or something, right? And
Mhm.
obviously in those cases, the government could say, well, what are you doing? We gave you this money to set up libraries and have classes and stuff. And obviously, it's not, they are doing that as well. But I think that by limiting free speech, they are sort of very much not doing what they're supposed to be doing. And in that case, well, what they're being paid to do, right? And in that case, I think it's justified for the government to say, hey, you've got to change course here. We've got 2 minutes left. So just very quickly, having watched all the proceedings of this case, when are we going to get a judgment and what do you expect is going to be the result?
Oh, so the judge said that she will have a decision before the end of term, which I think I looked up. It's like around the 1st of April. So it'll be before that. So it'll probably be sometime in March that we will get the judgment. So a few weeks from now, potentially to potentially the end of March. Which way the judge will rule is very hard for me to say. Even though I watched all 3 days, I felt that the OFS Council did a very good job at pushing back the points that Sussex had made. I think she was amazing, but the judge did seem sympathetic, I felt, on some of the points. Ground one and ground two were both very far reaching. And I was kind of worried that the judge did feel that at least at some point she was sympathetic to both of these grounds. Also, parts of ground three, I think she was. So potentially we could see a ruling against the OFS on any of these grounds. Also, potentially the fact that Sussex was the only institution to get a fine and that the OFS did not look at what other institutions had this policy and did not find them all, like the procedural grounds. So I think there are risks. It's very hard for me to predict which way it will go, but whatever happens, it will make a big impact and it will be appealed. I think I can safely predict that.
Okay, well, thanks very much, Abhishek, for following the case so closely.
Thank you, James.